Good afternoon, everyone. I'm Bob Fellmeth. I'm part of the faculty at the University of San Diego School of Law, and I direct the Children's Advocacy Institute. And we have with us here a very nice group to speak to you. We'll be hearing from me very briefly, and then from Amy and Betty and Danielle and Lisa and Kimberly down the road here. And they have some very interesting things to say, much more interesting than anything I have to say. So I'll try to be brief. I want to thank John Kerry, first of all, for supporting our cause and for getting us this room. And he couldn't be here because he had some Senate business to undertake, but he gave us a statement. I'm going to read it for you. This is the report that we and First Star, our colleagues, are releasing the second edition of the report, the State Secrecy and Child Deaths in the U.S., where we examine state laws pertaining to revelation of information about deaths and near deaths from child abuse and neglect. This is from Senator Kerry. This report underscores the importance of passing bipartisan legislation this year to start getting our arms around a chronic problem nationwide that we know too little about and have struggled to document properly. As a prosecutor in Massachusetts, this is he talking. I was a prosecutor in California. I saw with my own eyes the horrific results of crimes against children, and as a father, it makes me sick to think that too often abuse ends in death. It's more difficult to address a problem if we don't know the extent of it, and this report confirms that many states have either papered over the problems or failed to dedicate the resources needed to address it. We need to pass the Protect Our Kids Act to shine light on this issue and give child abuse the laser-like focus that's needed. That's from Senator Kerry. I'm going to thank Senator Kerry for that statement. It's very helpful, instructive. Now, we first did the first edition of this report with First Star in 2008, and we had documented an appalling number of states failing to disclose information about the child deaths caused from child abuse and neglect. Today, we estimate the number of deaths of more than 1,700 annually from child abuse and neglect. An additional 500,000 children are removed from their homes for protective purposes, and only a fraction of the cases we know are reported. We have a special problem with infants from 0 to 5 where they're not in school and are not subject to observation, and the reports there are especially sparse. The 2008 State Secrecy Report found that more often than not, states kept from the public information about these deaths. They're skewed toward protecting the confidentiality of potential perpetrators. State laws prevent the discovery of systemic flaws. And there are 2 points I want to make about this aspect. First is that the states have occupied this territory. This is not a debate over what the state's function should be. In every state in the Union, under federal law, 4B and 4E of the Social Security Act and the Child Abuse Prevention Treatment Act, or CAPTA, we have a very strong national and state policy in favor of protecting children from abuse and neglect by harmful parents or unfit parents. Secondly, we have an imbalance. And this imbalance is illustrated on page 12 of the report. The imbalance is this. If you're a social worker and you go into a home as a result of a mandated report, only 3 or 4% of the time you're going to remove the child. And you've got a decision to make. Removing the child improvidently is a serious mistake, obviously. It involves all sorts of harms and costs and damage that worries us. To prevent that harm, we have checks in the system, lots of checks. We have a federal requirement that there must be reasonable efforts not to remove. We have immediately going in front of a judge, a neutral authority, to prove that the detention is justified. We have reasonable efforts to reunify. We have a sequence of hearings. We have attorneys appointed for the parents. We have guardians ad litem appointed for the children. We have a series of hearings. We have, as I say, reasonable efforts to reunify as part of that. We have a burden on the state if the child is going to be removed from the parents, that the parents are unfit by clear and convincing evidence. All of these checks, and CAI and First Star support them all. We know the harm from improvident removal, and we support them all. But what is the check in the other direction? When the social worker says, no, I'm not removing this child. The answer is, if you look at page 12, a blank sheet. It's a blank space. There's nothing. There's only the law that this report documents. That's it. That's the only sign we have that the social workers are making a mistake. And social workers and public employees don't like this report, and they don't like these disclosures. Make them look bad. And I'll tell you, I sympathize in the sense that hindsight is 20/20, and sometimes we may draw a conclusion and swing the pendulum too far in one direction or the other. I'm aware of all that. But the imbalance is such that we need to know when they're not pulling kids and the kids die as a result. We need to know because oftentimes they're the result of policies that are in fact incorrect, that are wrong. When the kid in Sacramento, the girl in Sacramento is 7 years old, goes from 70 pounds to 50 pounds to 30 pounds in sequential visits, and you're not removing that child, and the child dies a week later, that's a problem. That's a problem in the system, and we need to know it in a democracy. Now, studies have shown that Child Protective Services have been involved with the majority of children ultimately end up dead. In other words, and this surprised me as well, we did a study in California of, okay, let's take every child death and research it, where we can find the information. We worked very hard to find the information. It wasn't easy. And we found, to my surprise, that a majority of those deaths involved prior Child Protective Service reports. I would have said, if you'd asked me, even as someone who's written in the field and studied the field for 20 years, I would have said 4, 5%, 10%. It's over half. And in fact, over half, the reports concern the cause of death. They're about the cause of death. That's why this report is so important and this law is so important. Okay, it's against this backdrop of this law and this obligation that we are providing an updated state-by-state report card about child abuse and neglect, death, and near deaths, and the public disclosure laws pertaining to them. Now, there have been some positive trends since 2008. There are some 10 states or so that have improved their grade. There are some states that have gone the other way, including my state of California, tragically. And there are many, many states that don't meet appropriate standards. There are some 26 states that probably do not meet the requirements of federal law under the Child Abuse Prevention and Treatment Act, that probably are challengeable, where probably DHHS should be withholding funds. And one of the problems is the funds coming through CAPTA are very small in amount. So DHHS says, well, maybe we won't threaten that state. Maybe we won't make them comply with the law. What's needed, among other things, is not only the carry bill here, we also need to attach the CAPTA requirements to 4E and 4B money. The second we do that, DHHS will have, I think, the incentive, we hope, to actually require the states to abide by the law. And they're the key here. It's easier for them to do it than to do it in court, as we've learned the hard way in California. Following the 2008 report, we had a bunch of other reports. We had the CAPTA reauthorization proceeding going on. Maybe tell you a little bit about that. We had the National Coalition to End Child Abuse Deaths Summit, and that's a group that's doing very important work on this subject. We had the GAO report. We had a CDC report. We have another report today on accidental deaths from the CDC. We contend that the Child Abuse Prevention and Treatment Act and the federal government have determined that the good that comes from disclosing this information outweighs the embarrassment it causes. Yet we have nearly 37 states, really, that are probably below the federal requirement, if you look at their performance in the report, and 26 states that are pretty darn low. And we have some Fs, states that don't even try. Fortunately, we have people standing before you, or I should say sitting before you today, who are tenacious advocates. With our colleagues and partners in every state, we don't intend to rest until state laws are enacted in each of them that meet the requirement of federal law and that provide this level of protection on this side of the scale. So we're going to hear first of all from Mindy Harfeld, who's the National Policy Director for the Children's Advocacy Institute, and she'll walk you some of the major findings of the 2012 State Secrecy Report, and then we'll hear down the line from the other speakers.